A trial date of January of 2026 is set for Arizona's fake electors case, in which allies of Donald Trump have been criminally charged for attempting to overturn the results of Arizona's 2020 presidential election. To help guide us through the latest on the case, we welcome Denton's law firm partner and former U.S. Attorney, Paul Charlton. Paul, good to see you again. Thanks for joining us. Yesterday and a little bit into today, what happened?
So this is a hearing, Ted, that was brought by the defendants, a number of them. As you know, there are 16 defendants, 11 of these who are accused of being false electors, to see if the judge will dismiss the case based upon a novel concept, a new law that only Arizona has in place, called an anti-SLAPP statute, which is designed, usually in civil cases, to protect people who are exercising their First Amendment right. And here, what the defendants in the false electors case say is that we were simply exercising our First Amendment right to talk about what we believed should happen during the election, and we are being prosecuted because of our political beliefs.
It sounds as though, again, as you mentioned, what they were saying is we're doing this just in case the Supreme Court rules X, Y, and Z, and we'd be ready. But and then they want that for dismissal. That sounds like the kind of thing you would bring up at a trial and not necessarily for dismissal.
It does, and they've got a couple of issues that they're trying to put in front of this judge. One of them is just that this was a contingent-based false election provision, if you will. So they said this was only going to be, we were only going to act as electors if there was a court decision that would support our view that the election should have gone for former President Trump, not for Biden. In fact, there are other states where that contingency was made very clear. Pennsylvania, for example, had a very clear provision within the documents that were submitted to the federal government saying, this is only going to take place. We are only going to be electors if there's a court case that allows us to be so. No such provision was put inside the Arizona document, and the State Attorney General's office says it is that kind of evidence that shows that these individuals knew that they were making a false statement and therefore should be subject to criminal prosecution.
And back to the anti-SLAPP statute, the state has to prove, you have to prove that the state, I should say, is motivated by the desire to prevent the exercise of your Constitution. You have to prove that. That's not an easy thing to prove, is it?
Well, it ought not to be, and because this is a new statute, because it's novel, because there's no case law to help this judge decide exactly what kind of burden of proof there's going to be, how it is he should look at the facts, this judge is going to be deciding this law for the very first time in the country. Now, what the defendants say is, look, we've heard Chris Mays, who was then a candidate for Attorney General, saying that she wanted to bring forward cases just like this, and that shows some sort of political bias or animus on her part to go after us as Republicans. She's a Democrat. That may not be sufficient. This judge is going to have to weigh what it is the correct outcome is. And he said yesterday in court, whatever I decide, 50% of the population is going to revile me, and other 50% may support my decision. He's in a very difficult position.
A difficult position, but he knows the score, so he certainly understands where he also knows that he's going to be questioned about the start of this trial. 2026? What's going on with that?
January 2026, and we've talked about this before, Ted. The three best defenses in any criminal prosecution are in this order: delay, delay, and delay. So if you can put this prosecution off, if you can tell the judge we aren't going to be ready for this case until January of 2026, some 6 years after the events that are alleged to have been a crime took place, the defense wins a victory because memories begin to fade, because the agents who may have been in charge of this investigation may retire, prosecutors may go off to take different jobs in private practice. Delay is bad for a prosecution. Delay is good for the defense. Now, the judge, in setting this date, pointed out that there are some 80 witnesses that all of these defendants are going to want to interview, a voluminous amount of paperwork that they're going to have to review. And so there is a legitimate reason to put this trial off. And some of this is going to be on the prosecution because they decided to bring such a large case with a very large number of defendants and a very large number of witnesses. And so it isn't unreasonable for the judge to say, we need to put this case off for a while.
Yeah, I want to get to that fact that there was 18, now there are 16 folks that are being tried here. But the prosecution said, okay, late summer, next year, we get that. That's understandable. That's reasonable. January of 2020, is a judge even going to still be on the bench at the time?
That's part of the problem. And the judge said this is a moving target. So I would expect that January 2026 may not be a firm trial date. We may see that date get pushed back yet again as this trial goes forward.
Could the date also be pushed forward? Could he basically say, you know what, I've reconsidered, let's make it September of 2025?
It would be a very rare thing for a judge
Interesting.
to accelerate the trial date. I think you may see trial dates go back, but for a judge to bring it forward would be very unusual.
Interesting. All right, the state also wants a protective order for grand jury, all sorts of grand jury information, because let's face it, they don't trust the defense attorneys, correct?
They don't trust other individuals who are, as you know, animated to bring violence against people who are just call it the MAGA movement. There are people who have been threatened with death threats. There are people who have been physically assaulted. And so what the State Attorney General's office is saying is we need to protect the identities of these grand jurors so that they aren't threatened as other grand jurors in other jurisdictions have been threatened. What the judge is saying is maybe there's a way that we can do this by simply redacting the names. We'll see if there isn't some compromise that we can come up with. That's a kind of a standard practice. Grand jurors are supposed to be protected. They're supposed to be secret. They're supposed to make their decisions in secret. So that part's not unusual. But the level of violence that we've seen in political discourse nowadays is such that that heightened awareness makes sense, and you can see why a judge would struggle to try to find a way to share this information but not to disclose it publicly.
I was going to say, but if I were one of the defendants and you're my attorney, I mean, at what point can we not talk about X because X is redacted or X is protected?
Precisely, and if your liberty interest is at risk, if you may
Yes.
go to prison in the event of a conviction, getting all of the information in your hands and being able to use what defenses may be available is going to be very important. That's what the defense attorneys are arguing. Prosecution says, no, let's keep as much redacted and much out of the hands as we can. The judge is going to have to split the baby here.
One last question here, just in terms of generalities, because someone actually asked me this, and I'm not quite sure. 16 people, okay, 16 people. The judge says a trial starts in January of 2026. Does it start for one person? Does it start for 8? Does it start for 16? Are these run concurrently? Do they run consecutively? How does this work?
As this is currently set up, the prosecution gets to make those decisions at the very beginning of the case. And the prosecution, by charging all 18, as you point out, now 16, because we have 2 plea agreements and 1 cooperating agreement, all of those 16 defendants are going to have a trial on the very same day, and it's going to move through for a number of months all at the same time. That is a tactical decision that the prosecution made here. Whether that is a tactical error at the end of the day, we'll just have to see. But Ted, there's a maxim in prosecutions. Big cases have big problems. And so if you're bringing that many defendants to trial at the same time, it is very hard to manipulate. And if you saw the images of the courtroom yesterday and today, you will see 3 prosecutors and 16 plus defense attorneys, each one making objections, each one making arguments. It is a slow and ponderous process. It's the process the prosecution has picked here. Whether that was the right decision at the end of the day, we'll just have to see.
I was going to say, you could have 1 out of 16 having a problem at the far end of the bench, and you got a slowing down.
This hearing itself has lasted 2 days, and in a normal case with 1 or 2 defendants, it would have been decided in a matter of hours. So it's a good example of what happens when you bring big cases such as this one.
You know, a crowded courtroom just with defendants and their attorneys, for goodness sake. Paul Charlton, again, Denton's former U.S. attorney. Always great to have you here. Thanks for joining us.
Thanks for having me, Ted.